As my son likes to say, here's a fun fact about trial. Do you know that during a pretrial conference, if one of the sides is not ready or prepared to discuss settlement, did you know that the judge can actually dismiss their case? You want to know why? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So now your case is coming up for a pretrial conference. It's close to trial. And now the judge tries to get the parties to enter into settlement discussions. And he turns to the plaintiff, the attorney who represents the injured victim. Counselor, what do you need to settle this case? And now we tell him what we need. The judge turns to the defense attorney and says, Counselor, what are you prepared to offer in this case? And he says, Judge, this is the first time I'm hearing plaintiff's settlement demand. I'm not prepared to have any settlement discussion whatsoever. And the judge starts to get steam coming out of his ears. Why? Because when the attorneys arrive in court for the purposes of a pretrial conference, the entire purpose is to try and get settlement negotiations going, to see whether or not the defense has evaluated the case, to see whether or not they have a position and are willing to talk or are not willing to talk. Because only then can the judge make an intelligent decision about whether or not to adjourn the matter so that now we can come back and have further discussions, or to go ahead and set the case down for trial. If the defense attorney doesn't have any information, now what he's done is he's hamstrung the judge, and now the judge is going to get upset. Hey, you knew that coming in here you were supposed to have an idea about whether or not you'd be able to settle this case. Now you're wasting my time, you're wasting everybody's time. Is that fair? Is that appropriate? And one of the things that's available to the judge is he could literally dismiss their answer. He could dismiss their claims, which would literally mean that we win by default. Now, does that really happen? Rarely, if ever, does that happen. But now, turn it around. Let's say we were not prepared, the plaintiff's attorney, the attorney who represents the injured victim, that we were not prepared to discuss settlement. The judge would then take out his anger and his wrath on us, and one of the options available to him would be that we would run the risk that he could dismiss our case, which means our case is finished and over. And if we disagreed, which we would then have to go through the appeals process. And it creates a whole series of legal issues that arise, all because one side or another is not prepared to go forward with settlement discussions, when the whole purpose of this conference is, come in, let's see if we can resolve this case. So why do I share this great information with you? I share it with you just to give you an inside look at what goes on in the litigation process in these civil matters here in New York involving accident cases and medical malpractice cases and wrongful death cases. You know, I realize you're watching this because you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit and you've got questions, you know what I'm going to say, right? Pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.